Hello, and welcome to episode 57 of Let's Talk Immigration. I'm Curtis Morrison, an attorney and founder of the law firm Morrison Urena, and that's why you're seeing me here. Today, I don't have a lot to talk about, but I'm here to take your questions and give you answers. So if you can drop those questions on Facebook or YouTube, that's the place where they pop up automatically. If you pop up on Telegram, usually someone on my team will see it and share it with me. So share your questions because I'm all about answering questions and sharing what I know. If I can't help you, I try to send you to the people that can. Which reminds me, yesterday I went to the ALA chapter holiday party, and it was a lot of fun. I was accompanied by my wonderful paralegal, Gomez, and we had a lot of fun. And I ran across a lot of my colleagues that are immigration attorneys that specialize in so many other different things. And I think specializing is where it's at. I met an immigration attorney that just really helps people that are athletes in the horse profession, like polo players, or they show horses, or they're jockeys. And I'm just like, wow, that's a niche. That's what that's called, where they just do one thing over and over and over. I think that's really cool. So if you come to me and I can't help you because it's not what I do, what I try to do is send you to somebody who that's what they do. That's the only thing they do. Okay. Okay. So one more thing I want to talk about, and then I'll jump into questions. A question that my team wants me to share with people is we see people come to us to hire us for a mandamus lawsuit for NVC mandamus. What that means is they're waiting for an interview that's not been scheduled. And this happens every few months where they hire us. We go in to look at their CIAC, log on to the CIAC, go to review notes, and they're not documentarily qualified, and they've received a message from the State Department that they need to do something different. Sometimes it's crazy. Like they uploaded a document landscape, and I can't remember which one's which. They need to just change the document and re-upload it differently, or they need a new police report or something like that. But they're not documentarily qualified. So it's very important to log onto your CIAC if you are waiting for an interview to make sure everything's okay there, right? Because a little glitch there can cause you not to get an interview for a very long time until you figure out that glitch. The State Department's not going to tell you about it. Okay, let's jump into questions. Caleb, DV 2020 game is over? Caleb, no. DV 2020 selectees who were not issued visas are Gomez class members, and we won summary judgment in the Gomez motion for summary judgment before Judge Mehta, and then the Biden administration appealed that order, and we are waiting on the outcome of that appeal. So even if we prevail in that, even if we beat that appeal, though, it's important to understand there are probably 40,000 DV 2020 selectees that are waiting for 9,095 visas. So it's not the ideal situation, but at the same time, it's getting better because as time goes by, those 40,000 people are finding other paths to advance their lives. They're immigrating to other countries, or they come into the U.S. on other immigration processes. They won DV 21, DV 2021, 2022, 2023. Are they came family-based? Are they sought asylum at the border? So that pool of people is actually getting smaller, which increases the odds for the people who are patient. It's interesting. So, but the game is not over, and it would be premature to come to that conclusion. Okay, MT says, is it too early to file a WAM, writ of mandamus is what that means, after 6 months of a I-485 submission? EB2 NIW PD 2021, June 2021, approved March 2028. I can't check to see if your case is current in the visa bulletin without knowing your country of chargeability. So just know that this advice is not including that. But I would say it's not too early, and let me tell you why. When you file a writ of mandamus, the goal is not to win a lawsuit. The goal is not to only file it when there's a 100% chance of success. The goal is to file it when there is a good chance that the government will decide to give us what we want so that we will go away. USCIS is better at that than the State Department. One thing I would need to know if you actually contacted me for a consult is where you're located in the US. I-485 is adjustment of status for those that are watching. And when you sue USCIS, you really need to sue them where you're located, where your petitioner's located. There has to be a geographic tie. So where you're at is where we'd file the lawsuit. Give me a call and we'll, or reach out to me and we'll talk more. Okay, Selena Hervine says, hello, what's the visa backlog of family immigrants F41 visa category at U.S. Embassy DACA? Great question. I do not have a recent declaration or exhibit from the State Department for the backlog at DACA. And let me tell you what that means. That means that when we file mandamus lawsuits for people that are stuck in the backlog at DACA, the government hasn't been fighting us. So we only get those declarations when they fight us. I will say that DACA's backlog is unique to most embassies' backlogs because there's an OIG report, Office of Inspector General, that came out in 2020 that said that they had a backlog before COVID. And it was because they were understaffed and nobody had tried to get the staffing. So I always like to include that as an allegation because the government likes to say, oh, our backlog is because of COVID. Not at DACA. They had a backlog before COVID. So anyway, I can't give you a precise answer on that. I suspect that there still is one because they started out before COVID with a backlog. Recommend a mandamus lawsuit. Contact me for more information about that. Okay. Malik says, any updates on the good luck case? Very close to the question that I got before on DV 2020. Good luck is DV 2021. I do not have an update. We are still awaiting the outcome of the appeal. Richie Lou says, hi, cutie. Well, hi, cutie, you too. Everybody can call me cutie. It's fine. Any update concerning good luck? No. Just to answer that question, we are still waiting for the outcome of the appeal. Okay. Anish says, hello, sir, DV 2020, please. It's not a question, but I've already answered that question of what it is. Okay. MT, yes, it is current. Good. Selena says, how does U.S. immigration law view children under the age of 10? Like, if something is wrong in their immigration or immigrant visa application, are they responsible or their parents or guardians? That is a complicated question depending on what is wrong in their immigration application, okay? And it's the subject of a lot of litigation. When I worked for Goldberg and Associates, we had a lawsuit that was about things that were put about a kid in a petition when this kid was an infant. And we see that a lot. And the really depends on what it was. Really depends on what the representation was. So, but the U.S. government can be unforgiving and punish the kids for mistakes that the parents made, which I think is the question that you're asking. So would need to know more information to give you guidance. Okay. Do you have any thoughts on the recent trends of consular officers asking about how many people live with the petitioner at the time of the interview and misunderstanding that as the household size for the affidavit of support, leading to the 221G and need for a joint sponsor? Layla, that is a great question. And by chance, I made a LegalNet inquiry on that very question at my friend Rabia's recommendation. And the answer that came back rather quickly, I was seeing if I could find it really fast. Basically, they said that's up to the consular officer. Like, because I tried to say, hey, it's custom in other places for different households to live under the same roof, but their finances are separate. So they should be separate households. And LegalNet, which is the attorneys for the State Department, responded to me that said, well, it's up to the consular officer. So it's a frustrating issue because it's one that will probably not get litigated because it involves people that don't have enough money. So how would they ever hire a lawyer to litigate it? So it's frustrating. It's frustrating. But basically the State Department's doing what they want there. And it's disproportionately causing harm to families in Pakistan and India and a lot of Muslim countries where the families stay together. It's not fair. Okay. If I am already DQ'd at NBC, and T is asking, but I decided to file an I-45 because I'm already in the US instead, does NBC need to return my file to USCIS before USCIS can approve my I-485? Interesting question. I think in part depends upon the visa category. I'm scrolling back to try to figure out your case. It's F4. No, it's EB2 and IW. And EB2. I'm not sure on that. I don't practice as much in that space. I do mostly lawsuits. Okay, so I don't know the answer to that question. I would find out if you were my client, and we would try it. But there's not a form. Like there's a form to make sure that USCIS sends the petition to NVC. There's not a form for NVC to send it back to USCIS. So from that perspective, I don't think it would be necessary, but I'm not sure. I would check it out if you're my client. Okay. Anas, hello. You look familiar. I've Googled that appeals take 6 months to appear. Why good luck is taking that long? What to do to rush it? I hope you realize, Anas, that not everything you find on Google is correct. There are appeals that take 6 months. This is a complicated appeal for a couple reasons. The legal issues at play will have consequences for immigration to the U.S. into the future, far into the future. Whether or not 212F authority for the president to suspend issuance of visas means that they can also suspend entry. I'm sorry, 212F authority to suspend entry also means that they can suspend issuance of visas. Is an important legal question, and the court realizes they need to get it right. Okay, you say what to do to rush it? I have no interest in rushing an appeals court decision. If you rush a decision, you're not going to get the best decision. You want the best decision. Okay, but also we can't. I mean, this was already an accelerated appeal. This is what an accelerated appeal looks like. So we don't want to, there's nothing we could do, but even if there was, we're better to let the court do what they need to do in the time they need to do it. Okay. It's just part of the appellate process. Okay, MT says, it has been 6 months since my 485 submission, but my case status on CIAC remains at NVC. Means that no one has bothered to recall my case files. So when you asked the last question, I thought you hadn't done it. Oh, so you have already done it. Oh, it sounds like you need an attorney. You're doing something complicated by yourself, and it sounds like something I wouldn't even do without doing research myself. So also, your case status on CIAC, that's a public-facing website. CIAC is often not correct. I don't know what you want your status on CIAC to say. What do you want it to say? MT decided to do a 485 instead. I mean, that's not a CIAC status. CIAC statuses are at NVC, ready, issued, refused. I mean, I guess there's something about return to USCIS when there's something wrong with the file, but I don't think I would look. Okay, you want to know what the status is of the 485, the USCIS process, and you're looking at the State Department's website. I just wouldn't rely on the CIAC to give you an update on what's going on. Also, 6 months is not very long for a 485. Okay. How long is it taking now to get a copy of an applicant's immigration file from State Department or USCIS filing FOIA? I don't know about USCIS because I've never used. It's just by chance I'm one of the few immigration attorneys that hasn't done that. I haven't done a FOIA for USCIS. I've done FOIAs for State Department visa files, and sometimes they take 9 months, sometimes they take a year and a half. So you could always litigate them too. We charge $4,000 for a FOIA lawsuit. That's where we sue the government because they haven't answered a Freedom of Information Act request. They're very successful. Okay, MT says, if I submit USCIS service request to expedite and ombudsman request to expedite, would this strengthen the weapon writ of mandamus case for the 485? Okay, your writ of mandamus case for the 485, difficult to strengthen it when it's only been 6 months since you applied. I mean, what I'm saying is that's not, anybody that looks at that will not say that's unreasonable, any judge. So an ombudsman request to expedite. I mean, all of those things could be exhibits in your writ of mandamus, but the longer the length of delay, the stronger. If you want to make the case stronger, make the delay longer. Okay. If you want the strongest writ of mandamus case, well, then stop talking about a writ of mandamus right now. Wait till about a year. Okay. With the writ of mandamus, it's not always about bringing the strongest case. It's about bringing a case and seeing what the government does. Sometimes we found that USCIS would rather make a case go away. Not always, but sometimes. Can CIAC status show return to USCIS? I think I've seen that CIAC status before. I can't remember exactly how it's worded, but it doesn't always show that. CIAC is not like, people think it's like the Bible. It's wrong. I know people that are living in the US with green cards. They're probably naturalized, that still their CIAC says ready or something. It's not always right. It's a public-facing website too. It's different from the State Department's internal system. Okay, MT says, would FOIA show the reason why my case was placed in administrative processing? Probably not. Definitely, probably not. So I guess that's definitely not. The visa cases we've got back, I did a while I was filing them for people that refused under 212A3B, and what I was seeing was that everything, it would be like 100 pages, And it's everything that's in your US CIS petition. And then some of the worksheets that the State Department used to make their decision, they just redact this stuff that the State Department put on it and said, nope, we're not going to provide this. It's all black, you know? So, and then there's some pages that were omitted that they didn't include. So I don't think it would show why you replaced in administrative processing. I don't think it would show that. That's a national security thing sometimes, and they don't want people to know. Especially, I mean, if it's a DS5535 form, it's definitely national security vetting. Okay. Freedom stance. In Gomez's case, what do you mean when you say those who did not receive a visa before April are eligible? Great question. There is a myth that all DV 2020 selectees are Gomez class members. That is not true. DV 2020 selectees who were issued visas are not Gomez class members. There were several DV 2020 selectees issued visas prior to April of 2020 who were unable to leave to enter the US because there are many Cubans that could not leave the island. I think there's many people from Algiers, a similar situation. There was a border closure. They couldn't leave. And so there were a lot of people with issued visas that couldn't leave, and those visas expired. And the Judge Mehta's order reserving visas and also the order for summary judgment in the Gomez matter did not do a carve out, did not rescue the people in those situations. So the class, the Gomez class, does not include people that had already been issued visas, but those visas expired because they were unable to enter. That's what I mean by that. I don't have an I-134 form, then what is the alternative? I don't know anything about your case right now. I don't know your visa category, so I don't even know why you're looking for an I-134 form. Okay, MT says, how long are DS5535 cases taking without a writ of mandamus? Have you won any writ of mandamus cases against the State Department recently? Okay, you're asking two questions. I'm going to separate them out. For the first question, how long are the cases taking without a writ of mandamus? Well, I think when you say cases, you're talking about applications. I don't use the word cases because I never know if they're talking about the lawsuit or the application, two different things. So you're talking about how long does it take to come out of vetting without a lawsuit? Well, there are people that haven't come out, so we don't know yet. It could take a long time, right? I filed a mandamus lawsuit over the weekend for someone that had been in, that had their interview in 2019. Earlier in the year, I filed a mandamus lawsuit that someone had been in vetting since like 2018. So it's not a queue, so I can't answer the question. The question presumes a queue. It's more of a pool, and we don't know when they're going to drag you out of AP. Okay, I did a poll in a Iranian Telegram group I'm in, and I think 500 people answered. They were all AP. That's what the group is, and more than 50% had been in AP more than 6 months. But there were so many outliers. I would say like 5 or 10% had been 1 to 2 years. That's scary. I did the same poll in a smaller WhatsApp group with Pakistanis in AP, and it wasn't as long. Most people had been in AP 3 to 6 months, but I can't tell if that was a group of people that, whether that's changing or it appeared, if you look at those two situations, that Iranians are staying in AP longer than other nationalities. That's what it appears to be. So anyway, the answer is you could be there a couple weeks, you could be there a couple years, and State Department's not going to tell you. You can go to Ankara's website, U.S. Embassy Ankara, and it says don't even ask them for an update on a case in AP if it's been less than 6 months. So that tells you right there, it could take some time. Second question, have you won any writ of mandamus cases against the Department of State recently? See, there you're using the word case to mean lawsuit. My goal is never to win a writ of mandamus lawsuit, because winning a lawsuit is not what I want. Getting the visas is what I want. We file a lawsuit, we annoy the State Department to where they realize it's easier to issue the visa than to answer to the court or to do the work involved with fighting a lawsuit. So the answer is, have you won any writ of mandamus? No, I haven't won. I've got hundreds of people visas this year, but I haven't won a lawsuit. I've won orders on motions to dismiss, where the government files a motion to dismiss. I file an opposition, government files a reply, judge issues an order saying that the motion is denied. That's what happened in Iqbal. Although that is not a DS 5535 case. There have been a couple of DS 5535 cases where that has happened. No. I want to say one is in Atlanta, but I might be wrong on that. I wrote a blog entry about it on my other law firm's website. You could find that. Go to my blog, Ready Go Law. I think it's 6 or 7 orders since September, and 2 of them were DS 5535 orders where the judges denied the government's motions to dismiss. So, which just means you go to the next stage of the lawsuit. Okay, that's all that means. Okay, my case is DV Lottery, scheduled for interview in 2020, but don't have an I-134 form. Okay, so I-134 forms were more important in 2020 because the Trump administration had adopted a more aggressive policy with respect to the public charge requirements. I think that embassies in the 2023 DV year handled that differently, because I know one embassy, I think Abu Dhabi, I might be wrong, said, no, we don't even need that anymore. Public charge is over, which is not accurate. And then others were still requiring it. So I don't know what's going to happen if we beat the appeal and the embassy wants your passport and wants to issue you a visa, a DV 2020 visa. I don't know if they will want an I-134 or not. People are issued DV 2020 visas without that form all the time, because that's just to calm the consular officer down if they have a concern about public charge. If they think you're going to be in the U.S. and you're going to be a burden on the U.S. government. If they don't believe that, then they won't even need that form. That form is more like insurance, okay? But also, the rules that embassies followed in 2020 when you were scheduled before are different rules now, like I said. Okay. Why doesn't US CIS use the DS 5535 if doing adjustment of status? Interesting question. There was a lawsuit, and part of that lawsuit, I wish I could find it quickly. Take me about 5 minutes to find it. There was a lawsuit, and the government said, we're not, well, basically, what is the DS 5535? It is 15 years of travel history and job history, and it's just more, it's the same information that's asked for on the DS 260, but it's just more of that information, okay? When the government, the Biden administration was going to be sued over this, they said, oh, okay, well, that's fine. This was like a long time ago. It might have been Trump administration. It's like 2019, 2020, I think. They said, oh, that's okay. We just won't collect that information. If we're going to get in trouble, that's fine. And State Department said, oh, we'll collect it after the interview. That's basically what happened. So that's why those supplemental questions come after the interview, because they didn't really, they'd have to go through the Federal Register. They'd have to change the law a little bit to ask those questions before the interview. I don't know if that answers your question exactly, but consular processing, adjustment of status, 2 different processes treated differently. One, meaning Department of State gives in and completes the DS 5535 vetting on a client rather than dealing with the lawsuit. I would agree that that is winning. Now, here is why that is difficult to measure. If you file a mandamus lawsuit because you're in DS 5535 vetting, administrative processing, the way the best outcome in the world is the embassy emails you to say, oh, the vetting's done. Give us your passport or get a new medical exam if it's been 6 months. And then you're like, yay. But you don't know if that happened because of the lawsuit or if it happened organically because they just randomly decided to do it. It's very rare that the State Department will admit that the lawsuit is the reason that they are accelerating an adjudication. By chance, I had them do it yesterday. Usually, government attorneys are careful not to do that, though. They do not want you to give me a way to advertise mandamus lawsuits, right? They'd rather like make it seem like they don't work. That's what the government's objective is. So I bring that up because it's difficult to say when you won a case or when things just happened outright, that you got lucky. You don't know. Okay. Muhammad Hassan, hello. New questioner. Yay. Why do you think state has been taking a more aggressive position on mandamus lawsuits recently? With all my heart, I believe it's because they want to use that more aggressive litigating as a deterrent so that people do not file mandamus lawsuits. And it's working. Many people are not filing mandamus lawsuits. And yet the people that are, we are still getting good outcomes for them, okay? It wasn't the outcomes we were getting before May or June where I just filed the lawsuit and 60 days later people were coming out of AP. Those days are gone. Now, unless the delay is long or there's significant hardship, what we're seeing now more often is we do have to file a motion to dismiss, creates another stage of the lawsuit, but then they come out of AP. So I think that they recognize after they have to fight it, they're like, oh, okay, whatever, let's just make the lawsuit go away. But I think it's the reason they're fighting these lawsuits is because they were escalating. There were more and more of them, and they had to think of a strategy to try to discourage it. And they said, well, we'll just file some motions to dismiss, and people will go on Telegram and complain about that, and then we won't have to file, and then people won't file mandamus lawsuits. And you got to give them credit because it deterred many of you. Okay. Why does the medical exam expire in 6 months at the NBC consulate versus 2 years at USCIS? It's because of what the law is. Yeah, I don't know the reasoning for the law. I would agree that probably does not make sense, but I didn't write the law. I don't know the reason for it. So, oh my gosh, I was not expecting so many great questions. Thank you all for so many great questions. I'll see you next Wednesday for episode 58 of Let's Talk Immigration. I hope that you are enjoying the holiday season and things are going good for you. Bye.